Hi everyone, welcome to ITLS Academy. Myself, Advocate Priyanka, and today I am going to continue with our last topic that was about the patent. For now, we are talking about the patents in our last session and last to last session also we talk about the patents only. So today we will talk about the patent registration process. As far we know that we have talked about patent search and what is patent, all these things. So now next topic is patent registration process and their post registration formalities, if there is any. We will see that also. So for today's session, I have added some contents as usual. So first we will see the highlights of previous session, and then we will see the patent filing process. After that we will see that is a patent application same for the USA, EU and India. I mean, we can say that across the globe, but here I have taken only three countries example. Or is it different? So we will see a comparative study of patent application in USA, EU and India also. And after that we will see that what is the importance of patent registration, why it is needed, why to need the patent grant too. So why all people are just running behind and okay, if I have invented something we need some patent grant, like this type of thing. So what is the importance of patent registration process? And then after that, at last we will see that patent post filing formalities. Is there any post filing formalities also after the patent grant, or you can say after the patent registration or after the patent filing? And if it is, then what are they? We will see that also. So first we will see the highlights of previous session. So in previous session, as I told earlier, we talked about the patent search. So what is patent search? Patent search is basically a search or process, as its name only telling that patent search is basically the search of patents. So why we do this search of patent? So we do this process to identify any existing same patent application, like any existing same related patent application, same related inventions in the public domain or not. So that's why this is the basically process of the patent search, and we do patent search for that. Now what is the need of patent search? Why to search these patent application related to our area? So first thing is that need of patent search to find the novelty of your application, then to save expenses on invention and to find potential infringers, like at the last moment you go and you see that okay, you have already an invention in your hand and now you go and do the patent search, novelty search, there you find that okay, your patent is not novel. So in this case it will be wastage of time, it will be wastage of resources, everything. But if you start the patent search from the starting, then you can go through the, I mean, go through the process or go through the what criteria are given, and then you can see that okay, what is the need of, I mean, if there is anything novel related to your application or not, or other similar application already in the market or already in the patent forum. So you can just change your patents or patent claims accordingly. So that will save your expenses as well as your time. Now to find potential infringer also you need to get the patent, I mean get the patent search. So you have to search that okay, anyone is using your patent, or anyone had just similar patent applications related to you. For that you can also do the patent search. Now there are, as we discussed, there are five basic types of patent search: novelty search, FTO search, invalidity search, state of the art search, landscape search. So here I am not going to tell all searches in details because we have already discussed. Okay, if you want to know in more detail, you can just comment in the given link. Now, what are the commonly used patent search? Obviously, if you are doing patent search, then you will go through the some patent search engines. Like you have to search anything on the internet, then you go through the Google search engine. So here for also patent search, there are various patent search engines. For India, mostly we use Google Patents, here you can find patents related all information. eSpaceNet, here you can find European patent related information. Patent scope, here you can find patents related to whatever filed in the through the PCT, like you can say international patent applications. Lens.org, here you can also go through the patent search. In pass, here you can find Indian patent search. USPTO, here you can find the United States granted patents. So these are the commonly used patent search engines in India, which are basically used or used by the patent examiners, or you can say patent analysts. Now we will move to our today's topic, that is the patent registration. So we did patent search. We found that okay, our patent is novel, our invention is novel. Then after, next step is to go for the registration of your invention. That is called the patent registration. So how will you get a patent in India and across the world? As we know that patent is not limited to the only, patent is territorial right. Of course it is territorial right, but it can be filed in other countries also. So territorial right, that doesn't mean that if you are Indian then you can file only patent in India. It means that you can file in patent in India, and for that your rights will be limited to India only. But if you file patent in France also, then your right will be extended to the France also, obviously according to their rules and norms. So for like there are three types of patent application. See, first is ordinary application through which you can file patent in India. So first of the step, what we discussed already, that we have to go through the patent search, and then there is filing of patent registration application. I mean, you will go and on the IPO site you will file the patent registration application, and then there will be preparation of patentability report that will be done by the patent examiners in the patent office. They will review of your application, and after that they will issue patent registration certificate if everything is fine. Otherwise you will have go for the examination. You will have a go for the some hearings, or you will have reply to the examination report, and after all the things patent registration will be issued. Now next is Paris Convention. So actually to file international through the India, there are two types of way. You can file through the Paris Convention, or you can file through the Patent Cooperation Treaty. So what is Paris Convention? Here you have to first file the local priority application. Like in India, you can file the local priority application. India can be your local priority application office. Now after that, within 12 months only, I mean you have time period of 12 months, that you can file application direct in each country. In this 12 months you can go on different company sites, patent sites or technologies, and you can research very well that in which country your technology will give you some gain, or in which country it is just wasted, and according to that you can file the patent application directly in each country. So for that you have sufficient time of 12 months. Now after that is Patent Cooperation Treaty. So here you have to file first priority application, and then like here also you file priority application, and then you have to file PCT application, which should be in the 12 months. But here after this also you have 30 to 31 month times to file, I mean to go through the each country where you wish to the file. So this is your international application. After that you can decide okay in which country you wish to process your application, or in which country you don't wish to process your application. So these are the ways by which you can file patent application in India as well as internationally also. So see here I have made one chart. So describe you that how you can file patent application in India. In earlier slide I just told you in general, but here step by step I will tell you. So see, first like you will file the patent application. it can be complete specification or it can be provisional application. So what is provisional application? Provisional application is actually a stage of your invention in which there are some works to be required to be done, or there can be some progress in future also in your work. So for that you file the first provisional application. But here you can see it is complete application. This stage you can file only when you have a complete invention. You know that okay, now nothing progress can be done in this invention, in this technology, so directly you can file the complete specification. So this provisional application you file because you here in India it's that first to file first will get patent. So you don't want that another come with the same technology and they get patent earlier to you. That's why it's mandatory if your invention is in earlier stage, not too earlier stage, but in earlier stage that there are some things left, you should file provisional application. Then here this point is important to be noted that within 12 months, like you filed it today, and after that on within 12 months, from 12 months from today, you have to file complete specification. If you will not file this complete specification in 12 months, your application will be abandoned. Now we will move to here, like you filed complete specification, or you directly file complete specification, or you file through here complete specification within 12 months. And after what will be done? After that your publication of application will be done. That is 18 months of time. So within 18 months of time you have to I mean your application will be published by the patent office. And now see here, by mistake I wrote 36 months, it is actually 31 month. So here you can request for examination within 36 months, sorry, within 31 months from your date of your prior application. If you have filed provisional application, then date of your prior application will be this date. But if you have filed directly complete specification, then date of the filing will be your this date. So this date will be not the date of the filing. Like you have grace period of 12 months of filing complete specification and then you filed. So here your priority date will be only the date of provisional application. And from these two dates, within 31 months, you have to file request for the examination. When you file the request for the examination, patent examiner will examine your application, and then some examination report will come. And if examination reports come to you and you have to prepare, I mean they have some grounds on which they can say that okay, your file cannot be processed, it is there some novelty lack or something, then you have to prepare the exam report to examination, that in generally we say RTFER. And then after that, if objection met, response to office action, like means what objection were raised by the Indian Patent Office, and your response, what you gave the response in that in respect of that objection, and if it is acceptable by office, then you will get the patent grant. But here if it is not acceptable, then there will be more hearings, and after that also if it is not acceptable, then your application will be rejected. But if all things will go well, you will get the patent here. So this is the basically patent registration process. Here as I told also earlier also, this thing should be clear that it is request for examination period, and now according to new amendment act amendment rule, 2024 amendment rule, it is 31 months, it's not 36 months, it's 6 written by mistake, so don't be confused with this. Now what are the comparative criteria for patent application? As I told in earlier that we will talk about the some comparative criteria for patent application. Is patent application equal for the for all across the globe, or like here we are talking about the India, and USA? So no, it's obviously it's not equal, there are some differences. So if we talk about the India, there is first to file, like no it's not I mean it's not important that who invented first. It's important that who first filed the patent application in Indian Patent Office, and who filed the first, they will get the patent, or their application will start process. In EU also it is first to file, but in USA it is first to invent. Who invented first will get the patent. Now, Indian patent application accept patent application in English language and Hindi language also. Here also I have the mistake that I didn't write Hindi. So in India it is English language and Hindi language. But here one point to be is important, that if you are filing your international application, your application internationally, and it is in Hindi language, then obviously you have to give the translation for that patent application in English language also. Now we will see what the EU rule says. So in EU, patent application should be in German, French, and English language only. So there are three language options: German, French, English. Here also, if you go to the, there are different so many countries in EU, and they have their own language. So if you go for the other countries, either you have to file in the local language or in the English language. Now USA Patent Office accept patent application only in English language. Here is no other option. Now, application must disclose the best mode of carrying out the invention. It is the mandatory criteria for the India. I mean, for filing patent application in India. In EU, applicant has no obligation to disclose the best mode of carrying out the invention. They can just disclose whatever it is. In USA, applicant must disclose. So here you can say in USA and in India, the mode of disclosing your invention, the way of mode of disclosing of invention is similar. That means it must be disclosed in the best mode of carrying out the invention. But here in Europe, it is not like any obligation on the applicant. Now, if we talk about the post grant opposition, so post-grant opposition in India can be filed only within 12 months of patent grant. Like today, any patent grant, and anyone wants to file some post-grant opposition on some basis, then he can file only 12 months from today's date. If after 12 months he wish to file or he file, it will be not accepted. In EU, this time period in 9 months, and in USA, it's also 12 months. Now we will see that why we are talking too much about the patent registration. What it's necessary, why it's necessary, why it's so important to file patent registration. Obviously, it needs money, it needs other resources. So why to waste? So I will tell you, definitely tell you that it is not the wastage of your money, or it is wastage of the resources. Patenting and innovation is very, very important, because when you get any patent, you have right to exclude others from using, making, and selling your product for 20 years. And 20 years is not less period to gain, I mean, economical gain, or you can say it will be your gain in your profile also, in skills also, and while maintaining to right to sell them item exclusively, you can sell it in the higher price, as it is your granted patent. No one can use this. So for inventors, why it is useful? They will obviously get the powerful market position. Like if you will uh, go in a market, you want some investors through your simple any technology, but instead of that you are going with a technology which has you have already patent, then obviously you will get more investors. Your position in the market will be more strong. Encouragement for more innovation. Obviously, if anyone gets some you can say some prize or something uh, in a respect of doing any work, then obviously that person will get more encouraged to do that work again. So here it is the same situation. If any inventor is getting these exclusive rights, and because of these rights he can have economical benefit also. So if any inventor is getting these things for his one research or for his one invention, then obviously he or she will be get encouraged to do more innovations. So that will increase the research and development in any country, which is the, you can say, basic criteria for progress of any country. So it will lead to the progress of country also. Now if you have some idea, some technology, and you are just using openly it in the market without patent, anyone can come and use it and you can't do anything. But if you have a patent, yeah, that you can say that IPR sealed. So if you have patent for that particular technology or for that particular product, then no one can use it. So basically it is the protection from theft of idea or product. So here you can see that how patent registration is important and how it is involved in the progress of inventor to the progress of country. Now we will see that after the post registration, like you did filing, you did you reply to the examination reports, and after all these things you got the patent. So is there any patent post registration formalities also? Yes, there are. So first is that renewal of patent every year till patent protection period, that is 20 years. So if you got patent, you have to renew it every year. There is some renewal fee till patent protection period. If you don't renew it, if you just leave it abandoned, then your patent protection will be it will be amended by the patent office. Now there is filing form 27, that is called working statement. So you have to, so as we know that for the patent it is basic criteria, industrial applicability. So you can say for this it is form 27. You have to show in financial years that okay, your patent is in working stage or not. If it is in working stage, how much it is the, I mean, where you used it, or what are your financial statement, like this type of things. And if it is not in working stage, then what is the problem, and because of what your application or your invention is not, now we cannot say application, we can say that patent, your patent is still not in the working state. So for these things, earlier once in every financial year we have to file this form 27, but after the patent rule amendment 2024, now we have to file this form 27 once in every 3 financial year. So obviously this new amendment reduced some burden on the form 27. Now if after the post registration there is any change in ownership, like you transferred your ownership to the someone else, or you gave some license to the others, everything must be updated in patent register. You have to go and you have to file that okay, these things have changed, owner has changed, or I have given license to others. So it should be in the record of patent register of the patent office. Now, as we discussed already, that post grant opposition can be filed within 1 year of patent grant. So if anyone files post grant opposition for your patent within 12 months, you will have to reply again for that opposition. And but if he files after the 12 months, you are not obliged to reply the reply that. But I can't say here that you are not obliged. Actually, patent office will be only reject their patent post grant opposition. So, and if you also wish to oppose any granted patent, then you should also file post grant opposition within 1 year of that patent grant date. So it was the patent post registration formalities. So now it's the time of no to your curiosity. So as I told that in earlier session we talked about the patent searching, need of patent search, and all the things that how we can do patent search. I gave you some demo, not demo, or I gave you some screenshots of Indian patent search also. And that time I have left one unanswered question, that was the patent filing and post filing. So obviously now in this session I hope that I have met your all unanswered questions which was in earlier session. So I have cleared that what is the patent filing, what is the patent registration process, how you can file in the India, and how you can file your applications internationally, what are the time periods, and I also mentioned that what are the post filing formalities to filing form 27, renewal fee, all these things we discussed today. So for next, as you can see that in mid I was talking about the new amendments rule in the patent. So in next session we will go through that what are the actually patent rule amendments 2024, according to what things have changed, and then we will see that patent infringement also, like theft of patent, and what are the, I mean, what is the patent infringement, and if your patent is infringed then what are their provisions in the patent act or so. And then we will see that international treaties of patent protection, as we know that we can file our patent application internationally, so there are some international treaties for that patent protection. So if you are curious to know all these things, and you want to know that about the new rules about the infringement, then please be keep tuned with us. And obviously if you have any doubts in this session or in any other session, you can just write in the comment box, and if you want to introduce some other topic you can also write that, and then definitely I will go through that topics, or I will go through your diet doubts. So I hope that for today you all are clear, and if there is any problem please write in the comment section, and please follow ITLS Academy on LinkedIn, WhatsApp. You can find in every social media ITLS Academy. And thank you so much for watching. And keep tuned with us for the next sessions. That can be, I mean, not that can be, definitely that is going to be more interesting about the patent infringement, and as I told about patent new amendment rules. So hope to see you all in the next session. Thank you so much.